Okay, let's begin. Today will be our last lecture. And good luck with your exams from next week. But anyway, so today at least we want to go through an actual template of a joint venture agreement. It's a simple template, and I chose a simple template because I think rather than complicating with issues, I want you to first of all see the overall picture of what joint venture agreement is like when you particularly in establishing a new company. Okay, you create joint venture by establishing a new company. With respect to creating a joint venture through investing in an existing company, the complicated issue of valuation, due diligence, and then, negotiation, which entails a lot of representation and warranties about the company, because based on that representations and warranties, okay, you are making valuation. Because even if you conduct due diligence, unless the information is publicly available information, other information about the company is strictly limited to those information that are disclosed, okay, by the company. For example, list of material contracts. How do you make sure that what they have disclosed is all the material contract that there is? So you have to then make the representation and warranty that what you have disclosed to me consists of all the material contract, right? And then there are no other contracts other than what we have disclosed to you. Then you have to also define what material contract is all about, right? And then you have to say okay, so these are the material contract, that is fine, but is there any breach? Okay? If we breached under this material contract, then maybe we need to compensate for damages we have caused. Maybe they will terminate this contract, which is kind of necessary, right? So you have to make a representation and warranty about there is no breach of any of these agreements, right? And as far as we are concerned, as far as in my knowledge, there is no breach by the counterparty, right? So you would need all these things in the representation and warranty for material contracts. But there is not just material contract. There are other assets. There are assets such as intangible assets, such as intellectual property. There are tangible assets like personal property or real estate. You have to say, I have this valid title. You have to list those things. There is no other real estate owned by me, and the real estate that was owned is revealed to you, and then the person who is conducting the due diligence can check the title, whether there are any liens on it. Okay, you go to the real estate registry and you can check it, right? But you have to say there are no other contracts to sell this real estate. It's in a right? So you have a valid title, and then you have no lien. You have to make all those statements about the real estate, and also personal property like equipment, machinery, and things of that sort. How do you know unless you go and check every machinery that they are in good order or good condition, right? Because you are valuing, right, based on your financial statement, you are valuing it. But financial statement does not say all these machineries are in good order and nothing's been broken and anything of that sort. Okay? So your valuation depends on it's a set of assumptions, and the representation and warranties state those set of assumptions based on which you are making those valuations. So, but we don't need that if we establish a new company. Right? Because you are creating just a fresh, with a fresh new capital, a new company. So in this situation, I just want you to see what are the main topics. And depending on the situation, each of these topics can be expanded, but basically they follow this kind of structure, right? Okay. And in that sense, the template is for that purpose, but it doesn't matter if it's created for to be used in Korea. This is such a general form that you will kind of see what this general form will be about. Okay. All right. So based on that, let's take a look at it. This joint venture agreement is made on when, the date, by and between the parties, right? The two companies. And the company that is incorporated in the Republic of Korea and having its principal office at company address, Korea. The reason, okay, so this is introductory paragraph, so-called. In the format of any agreement, there would be introductory paragraph where you describe the name of the parties to this agreement. And when you describe the name of the parties, especially when they are entered into between the companies, you would write down their legal name, the company name, and then also the principal office. The reason being is that, and also state that if it's a legal entity, where it is formed, okay, the jurisdiction under which it is formed, so that you know, okay, if you know the company name, where it is formed, and what its registered principal office is, so that, okay, when after all things have gone through, you have to write a notice to them, and they don't respond, then you have to write a notice often to your registered principal office. You have to, when you sue, you have to send the notice to, okay, you have to serve the notice, complaint to the registered principal office. So usually, after the company name, jurisdiction, and the address of the principal office. Okay, so obviously this is defined as foreign investor because it's making investment into that country, and that country's partner in that country is a domestic investor. The recital. Now, after introductory paragraph, there's a recital part. The recital part should be brief as possible. You don't need to, but it basically describes as concisely as possible why the parties are entering into this agreement. What's the background, right? Usually they say, you know, this guy is engaged in this, that guy is engaged in that. You know, they want to create a joint venture company. For what reason? Now they agree, or something of that sort, okay? So here, it's just very brief because it's foreign investor and domestic investor desire to cooperate in the establishment of a new company to be organized under laws of that foreign country for the purpose of engaging in the business of what kind of business in the territory. And because the territory is defined and it comes out before the definition section, and you say as defined before. Then company is that joint venture company. Then force majeure, okay, is an event beyond reasonable control of the parties. The reason why there's a force majeure is, for example, when there's a force majeure event, meaning that it's an event that is beyond a reasonable control. Now, I am the supplier. Let's say I am a supplier, okay, and I have to supply something, and I agree to supply you something. However, when I was going to supply you with this product, suddenly there was an embargo, okay, placed that I am not able to, supply, or there is a war, or some kind of, things that was beyond my control that I could not happen. And though, therefore, I could not perform my obligation, but I should not, under this situation, be responsible for breach, because there was no intention to breach. There's no way that I could have expected it or prevented it, and this happened, right? So, usually in a supply situation, can I turn this light on? Okay, this light on, okay. So, in a supply situation, there's a supplier, okay? Well, and then there's a supplier to this recipient. Usually in this situation, defining force majeure widely, okay, widely to cover, okay, would work for supplier, because when you are manufacturing something and supply, there's a lot of things that has to go through in this side, right? Whereas this guy just pays the money and receives it, all right? So probably the only thing that he needs to do is able to send the money. Whereas this guy, there's a lot of things. They have to, import the raw material, then there has to be a design, there has to be something their house, manufacturing house could be on fire, warehouse could be on fire, whatever, right? So it is in their interest to broaden the scope of force majeure, because most likely the force majeure, if it happens, it will happen from this side, more likely so, right? So you'd like to expand the force majeure. Let's give an example of what this is. Shall mean conditions beyond the reasonable control of affected party or its subcontractor, including but not limited to acts of God or governmental, civil, or military authorities, continuing domestic or international conflicts such as wars, insurrections, strikes, labor dispute, sabotages, lockouts, explosions, fire, flood, earthquake, and embargoes. Notice such things as strike and labor disputes. Obviously, when force majeure is defined this way, okay, this guy, here is the guy who is supplying, and the force majeure is written in that favor. So this is a Korean party who, by just looking at the definition, it would be the Korean party who would be the supplier. Okay? And this guy probably is just a distributor. So this guy, since that guy has to supply, there's a labor dispute. If I have a labor dispute, labor strike, and cannot manufacture, then it's not, according to this definition, well, I am not really breaching the obligation to supply. Even if it causes you some damages and unexpected delays and things of that sort, right? Okay? From this side, if the agreement was drafted from this side, you'd really want to limit the scope of force majeure to really absolute, like, beyond control thing. War, earthquake, That's why it's called act of God. Flood, but not labor disputes. Or even here, more affected party or its subcontractor. Remember, see, why does it matter whether what happened to subcontractor matters? It's supposed to be your responsibility to deal with the subcontractor, find something alternative if that happens. But just by looking at this definition, you know that it's been written from the supplier's perspective, right? Okay, so that's how it goes. Fires too, Yeah, fire happens, but how did fire happen, So things of that sort, okay? Laws shall mean the laws of the country, usually, because when the JV is established under this country, right? then the laws of that country usually applies to JV. So that's why. Okay. Party shall mean the foreign investor and domestic investor, and party shall mean either of them. And then there's this definition of person. Person is intended to incorporate a very many types of entities as well as natural person. So any individual means like natural person. And then you want to say, you want to include a kind of broad types of entities. Could be partnership, firm, corporation, association, trust, unincorporated organization, joint venture, limited liability company, governmental authority, or other entity. It is defined this way. Product shall mean whatever that product should be. Okay? You define the product. Related agreement means once the JV is established, obviously under this structure, what they want to do is you want the JV to take the role of a distributor, right? So this guy will supply, okay? If the JV is doing the distribution, obviously there should be, once this JV agreement, JV is established, there has to be an agreement of supply and distribute, whether you call it supply agreement or distribution agreement, there has to be that kind of agreement must take place. If JV not only act as a distributor, if it will also act as a kind of manufacturer eventually, then there has to be a licensing agreement where this guy licensed technology to manufacture this company. Not only the technology, but trademark, right? And so on and so on. So those are whatever those related agreements are, shall mean such other agreement and document that are reasonably necessary in order to perform the purpose of this agreement, including but not limited to the articles of association, the agreements to be entered into by the company in relation to the purpose of this agreement. So it is defined that way. Share means actually the shares of this JV company. So you know that since they are using the term share, it's going to be a corporation, right? If it's a limited liability company, then they will use some other term suited for that. For example, unit, okay, or something like that. Shareholders. Territory. Territory usually defines if they want to distribute, the supplier wants to make sure that you only distribute in your jurisdiction, not somewhere else, because I will, okay, distribute by appointing separate, distributor or entering into joint venture and make that joint venture distribute whatever. So they have to define a territory. Okay, if it's South America, if this country is if JV is established in a country in the South America, it could be the entire territory of South America, or it could be something, right? Or smaller than that. So that's basically you have to define the territory. Okay, purpose. The purpose of this agreement is to provide for the establishment and operation by the parties of a joint venture company. Yeah, the purpose of this agreement, note, is to set forth the relevant matters regarding establishment, and after its establishment, how it will be operated, right? So establishment and operation. Operation including the management of the company. The purpose of the company are, and then A, developing and manufacturing of the products in the territory. Okay, not only you develop and manufacture products, distribution and market products exclusively in the territory, and engaging in any and all other conduct, activity, business which are related to the foregoing. So usually it's those key matters and then incidental those matters that are incidental, right? So obviously by looking at it, you know what the purposes are, okay? That this JV will develop and manufacture the product in the territory. Usually these purposes need to be set so that JV does not engage in something else. When you want to create a JV, you want to be specific what the JV intends to do, right? So you don't want some broad thing like JV will be allowed everything and anything that legally allowed to do, kind of thing. When it's 100% owned subsidiary, you probably could say the purpose is anything that is allowed by law. But when you enter into JV, then you'd limit that, okay, to specifically what the purpose of this is for. So that this purpose, if it's required in the articles, will also be repeated in the articles of association, okay? And then company shall have and then there was a tip saying that if now since this is a Korean party, this agreement is written for the Korean party who wants to establish the JV from here. Usually when the JV is established in this way, here the supplier relies on this partner, okay, for the operation of this company because they know the local market well. So most likely that the CEO of this company will be nominated by this guy because they don't know, okay, who is capable of doing that. Otherwise, they would not enter into a joint venture agreement with a partner. Now, I have the technology, I have the means to produce this product, but you know the market, right? You know how to operate, and therefore, it is likely this JV will actually be managed by the other joint venture partner, and therefore you want to be specific about, the purposes. That's what this comment says, okay? The company shall have the exclusive right to distribute and market product in the territory. So obviously once the product, whether it is manufactured here or initially be supplied by here, you want to have an exclusive distributorship right, okay, in this territory. So now one of the related agreement would be a exclusive distribution agreement between the joint venture company and the Korean party, the supplier. Turning into a next section, obviously states joint venture company articles of association and related agreement. Promptly after the signing of this agreement, foreign investor and domestic investors shall cooperate to incorporate the company under the laws. Obviously, you have to establish JV first. And then company's articles of association, basically how that company is will be set out in the articles of association. And articles of association shall be in accordance with this agreement. And if there's any discrepancy between articles and this agreement, then the company's articles needs to be amended in accordance with this agreement, right? So, which is priority? The agreement of this, this joint venture agreement where the joint venture partners agree, okay, is a priority. If it ever happens that articles of association adopted by the JV comes to be in disagreement with what the parties have agreed, obviously this is a fundamental company, but since these articles of association or articles of incorporation, however you call it, is the fundamental governing organizational document, just like constitution with respect to this nation. This is the constitution with respect to this JV, right? So therefore, they need to be amended, and you want the parties, because they will nominate the board of not the board of directors. Amendment is by what? Through the shareholders. So each party agrees to amend, give its vote, okay, to amend this article to be in accordance with this agreement. Otherwise, it turns out to be if articles of association are a certain way, it does not agree with this, but it favors one party, right? Then the other party is unwilling to do so unless there is a provision that these articles must be amended to be in accordance with this agreement, right? Okay. And then parties shall execute and shall procure the company to execute related agreement as soon as practicable after the execution of this agreement, whereby the terms and conditions of such agreement shall become enforceable by and against the company. If there's a set of agreement that needs to be entered into, I think this might as well be entered into to be attached to this agreement, the form of it. Okay, it's attached to this agreement so that when the JV is actually formed, you can sign. If those agreements are important, they can just attach it to this agreement so that as soon as the JV is formed, JV can sign the agreement. Okay? Now obviously next is a formation of the joint venture. And how do you form? It's a capital subscription, right? So foreign investor, domestic investor shall respectively subscribe percentages of the shares, right? They can agree to do 50-50. Usually for this perspective, 50-50 is difficult because of the deadlock situation. Then you have to agree, many of the things you have to really agree on, but there's no way that you can agree on everything ahead of the time. The agreement will become longer. So if situation permits that if you could have the majority, okay, it is preferable to have a majority by the Korean party, right? So, but you have to decide on what percentage that is. So this guy could have a majority, or this guy could have 50-50. This guy could have minority, right? Now, if it happens that this guy is minority, then obviously you want a very strong veto rights that on all major decisions, my consent is needed, right? If you were to have the majority, obviously you want a very little veto right of the other party, right? Okay? So, and then you have to say, okay, for that, how much shares, how many shares each one will have. If it's 70-30, then how many shares you will have. You will state it. Okay. Then whether it's by cash or by in-kind. If it's by in-kind, regarding the valuation and other things, you would need provisions for that. But for simplicity here, it's just cash, right? And then obviously 4.3, what kind of shares? Is common shares, registered in non-bearer form, evidenced by share certificate as provided in the articles of association. Registered shares are in non-bearer form, right? Okay. Well, another way of doing so would be having a different type of shares. This guy you would have common shares. But I want to have preferred shares. So when you have preferred shares, obviously, as the name implies, it has certain preferences over common shares, right? Preferred shares can be voting, and obviously you want to have voting shares, right? So obviously, in terms of voting, it doesn't matter. But preference in usually in what? What kind of preference does it have? Well, usually it's with dividend, then liquidation preference. Usually these two, right? And obviously, you're talking about dividend, 배당, right? There are those terms. There are different terms about dividend. You can, for example, can say, I want absolute, let's say 5%. It could work as an interest, right, on the investment. I want minimum of 5%. Right? But however, think about this situation. This is not loan. Dividend is only possible if you have retained earning, right? You have to have a profit in order to distribute it as dividend, right? You cannot make a dividend when you are suffering loss, right? So even if it states 5%, but it's contingent on the company making money and have enough retained profit, right? Assuming that it has retained profit. So for this year, they were unable to pay. That year, they were unable. But third year, they made a profit, so they could pay. What happened to the 5%? 5% here that was unpaid. Will you forget about it? Or will you include this, okay, all of it, so that you have to pay all this amount first? Okay, and what are these called? If you say you have to pay all of these unpaid dividend first for the preferred shares, what kind of dividend structure is that? It's called cumulative dividends, right? What has been unpaid is cumulates, okay? So this has to be all cumulated and paid before any leftover can be distributed to the common shares, right? So this is a cumulative. Now this is all in Korean commercial code too. It could be on the bar exam, I'm sure. And then, okay, so they have satisfied all of this. You made so much money on the third year, and there is this much left over. Okay? Okay? Will this then just distribute to the common shares? Or after all of this will be equally distributed to preferred and common shares. Okay? After all of this mandatory dividend has been paid, if the leftover, if the preferred shares could participate in this dividend as well, it is called participatory. Okay? Participating. All right? So dividend has these features. Is it cumulative or not cumulative? If it's not cumulative, then this year there is no retained earning, forget it. Okay? There has been so little retained earning, there was only 3% could be paid over. But what about the 2% that was not paid paid off. Forget it. Okay? If it's not cumulative, you'd forget about it and just concentrate on that year. If it's not participating, all this leftover could go to the common shares. If it's participating, then it has to be shared with common and preferred shares. Right? A liquidation preference. When company now is liquidated, okay, the JV is just liquidated, dissolution, then out of the entire sale of the company, whatever assets, you liquidate. You sell whatever that you can and get all this money, okay? There are money here. First, it shall go to the creditors, okay? You have to go to the creditors and pay off anything. Creditor first. If there's any loan, you have to pay it off, okay? If there's any trade payables, you have to pay to the partners, right? And then after you satisfy the creditors, if there's anything left over, then it goes to the shareholders. Obviously, you want to have in that distribution some preference. If it's good enough, then you can just distribute enough, okay? But this preferred says, well, if there is a dividend that has been unpaid and accumulated, then that is for me first, okay? I want to take that off. And then my shares need to be, okay? My ownership needs to have preference in this liquidation. If there's a little liquidation, it is not able to go to all the shares. It has to come to me, okay, first, kind of a thing, not equally distributed. Okay, so you will have some preference in that too. That all depends on that kind of features needs to be distributed, needs to be stated. But usually this kind of preference structure is usually used when there's not by two strategic investors, but usually when there is a financial investor just investing money. Then obviously that financial investor, FI, you would call it. Strategic investor, you would call it SI, shorthand. The financial investor would be interested in getting the rate of return, right? So they want to have all this structure. They want to invest and have shares in preferred, right? Usually they don't want to control the company because they are usually financial investors. So they take minority shares, but they have a very strong voting rights, veto rights. They do it in the preferred shares, and that preferred share is usually convertible. Okay, 전환 가능, convertible into common shares. Why? Because their exit mechanism, if they don't make the profit as expected, how can they exit? Okay, they want to, there's a various kind of exit mechanism that they can think about. They can have a put option where you can sell your shares at pre-agreed with the joint venture partner. Okay? Or if then company goes IPO, right? Then obviously through that IPO you can sell your shares in the market. So then these preferred shares before IPO needs to be converted into common shares, right? And so on and so on. So anyway, too much detail. So, but here, for the simplicity, because these are two strategic investors, you just want to concentrate, just focus on make it simple. That's your common shares, okay? And not preferred shares. So you don't need to think about whether dividend, but liquidation preference and things of that sort. But if it's preferred, but even between strategic, depending on your needs and situation, you could make it as, preferred share investment. That, either party, one of the party could have preferred shares if you have the leverage to negotiate it like that. Okay. All right. And then so after that you are established. The simplest form of establishment is you want to have certain, okay, what's the percentage you're going to have? And let's just contribute cash, because in kind, there is more complexities involved about valuation and also the time, you know. But anyway, so once that is established, then I think, as the next topic says, very important aspect of this is transfer restriction. Transfer restriction is very important because as a joint venture partner, hey, it's you that I'm entering into a joint venture. I'm entering into a marriage because if it's you. It's not like you can transfer and substitute somebody else, okay? Therefore, they have to restrict the transfer. The strongest way would just prohibit the transfer as long as the joint venture continues, right? And it would make sense. Okay? No party. The simplest way to prohibit is to state that no party would transfer shares without the other party's prior written consent, right? Prior written consent. However, if you are a corporation having many affiliates, maybe it makes sense to structure that later on within your group. You know, it works best if I could transfer my shares to an affiliate, right? So that's where the definition of affiliate comes in, right? Okay. No transfer without the other guy's consent, but let's waive it in a situation where you transfer to your affiliate. Affiliate by definition is controlled by, okay, controlled by, or under common control with, okay? So if I am here, any company that controls me, controlled by, okay, controls or I control you, if this is JV, if it is one of the party, joint venture party, then I'm controlled by under common control with. This is under common control with. So this one, that one, and that one are my affiliates. Now, under the definition of under common control, there could be many, right? Many sister companies, so sister, parent, and child. Okay, this is called child, 자회사, subsidiary, parent, okay, and then there are sister companies. All right. However, even if you prohibit, this is a prohibition on voluntary transfer. What about you get transferred involuntarily? How does your stock transfer involuntarily? Your stock transfers involuntarily when, for example, when you get financing, and then as a result of financing, you give your stock as a pledge to secure the financing. And then later on you are unable to pay, and then creditor takes the ownership of the shares, right? So not only voluntary transfer, but you have to prohibit, not the transfer, but this is a encumbrance. Okay, 담보 제공. You are prohibited from providing this stock, right, as a security, okay, as a collateral to secure any other obligation or any other rights of another party. Okay? So that is why, if you look at it, may not sell, assign, or transfer any of his shares in the company or any part thereof, or permits such shares or any part thereof to be subject to any pledge or encumbrance of any kind, right? Except as provided, etc. Okay. So that's the basis of transfer restrictions. Okay? And then the next one, 5.2, goes a little bit more specific into situation to the extent that any transfer of shares by a shareholder is permitted under this agreement. If permitted under this agreement, for example, a transfer to an affiliate, as you will see, such transfer shall be for all and not less than all of the transferring shareholder's shares and shall be made to only a single transferee. Suppose it makes sense to allow transfer to an affiliate. All right, I own 50% shares of this JV. I transfer 5%, I transfer 6%, I transfer 8%, and somehow I transfer various number of shares. Then it becomes really complicated, right? So what it says here is that, okay, you can probably, even if you are permitted under, you only transfer 100% of your shares to that transfer, to a single transferee. That's what it says, okay? There could be many different kind of a situation depending on your need. All right, and then it says, a transferring shareholder may transfer his shares to its affiliate. Okay? And then if now you come back to the definition of affiliate, this is the typical mean. 1.2 means with respect to any person. And now as you remember, the person is defined as person, individual, it could be any entity, etc., right? So that any person that directly or indirectly, that's an important word. You can have direct control or indirectly through one or more intermediaries. Okay? So not only parent but grandparent could be it, right? Right? Control. Not only your child but grandchild. Subsidiary of the subsidiaries, right? It's not direct control, but indirectly, right? Think about it. One or more intermediaries controls, is controlled by, or is under common control with such specific person. Okay, that's fine. Understand the structure. Now, what does that control means? Possession directly or indirectly of the power to direct or cause the direction of the affairs or management of a person, whether through the ownership of voting shares or securities. Okay, the term securities is broader than shares, right? By contract or otherwise. Okay, it's the power to direct the affairs of management. Okay, it's power of management. Whether by reason of having enough shares or ownership, or even if I don't have 50% or more, I can still control that. In case of, let's say, Samsung, they don't own 51% all the time, but as they can have 20%, but can still control. Okay. Right? In any situation, it's a public company, you don't necessarily need to have 50% plus 1 in order to have control. You can have less shares, but still be the largest shareholder. Okay? Right? And can cause the direction of the management. So, how do you cause that direction? Only by having shares? No. by having certain kind of agreement too. A voting agreement to vote it this way or that way, 그지? Right? That's by contract. Okay? Usually ownership by contract, or there could be something else too. So that's why the catch-all phrase have or otherwise. All right? This is a very common definition of an affiliate, a very important definition. From this on, there could be a lot of variation depending on the situation, right? But it's an important kind of a definition to know. It's a useful definition to know. Okay, so affiliate, you are able to transfer to an affiliate, but what happens? What happens? What happens? I transfer to an affiliate, but this affiliate is just a paper company, right? You can establish a company. There's no minimum capital. You can just establish the company with, let's say, Korean won of 1 million Korean won. Ooh, with paid-in capital of 1 million, which is not a lot, right? You can establish a company, then transfer all of it. What if then this guy later on do not keep the JB? Do not keep the agreement, JVA. You want to go after this guy for damages, but this guy only has $1 million, right? In order to prevent that situation, even if it's control, okay, but there's no, it's not the same thing. This guy is just don't have any money. So we don't let you go. You transfer, but we don't let you go. Okay, that guy may exercise the ownership, but you have to guarantee. If this guy do not perform as agreed, you have to put the guarantee, right? So, well, think about it. Okay, so that affiliate has to sign. The affiliate transferee agrees to be bound by and subject to the terms and conditions of this agreement, important. The transferring shareholder, the one who transfers, right, remains together with the affiliate transferee, jointly and severally liable. Okay, 연대보증, right? With respect to matters pertaining to the ownership of shares being transferred and the performance of obligation under this agreement. And what if later on you transfer, but this guy no longer remains transferred? Let's say at this point you had 50 plus 1 shares, but later on sold the shares to the other partner. Okay, now you only own 45%, or let's say just 30% of this company. Then this is no longer an affiliate, right? What happens to that, even if you transfer? The affiliate transferee agrees to transfer back the shares to the transferring shareholder in the event that it no longer remains an affiliate of the transferring shareholder. You understand how it logically makes sense to prevent that, right? Right? There could be variations, but this is kind of basics, okay? All right, any attempted transfer of share that is not permitted or otherwise violates this Article 5.2 or other terms and conditions of this agreement shall be deemed null and void ab initio. But even if you say null and void from ab initio, from like beginning, as if it didn't happen, you know, he says any transfer that violates is null and void. 무효. But even if you say it, once that transfer is made in violation of this agreement, oftentimes that transfer, if it's a bona fide purchaser, that transfer itself remains valid. Why? Because the fundamental characteristic, fundamental feature of stock is transferability. right? So if a bona fide purchaser, okay, purchases believing that that guy, not aware of this restriction, if he purchases that, what happens? Even though I may go after the transferring shareholder for some damages under the breach of the contract, still the shares are I cannot invalidate the share transfer. In Korea, therefore, there is such a thing called getting a board approval for share transfer, as I explained last time, right? But, so the key feature is that I have to prevent somebody buying the shares and claiming that I'm a bona fide purchaser, right? Not aware of this kind of restriction. So how do you prevent that? How do you make somebody aware? This is not a matter that is, share ownership is not a matter that is on the commercial registry, okay? Because basically because of the transferability of shares. It's transferable. You cannot make it register each time the share ownership. So share ownership does not appear. Okay, it's not a public document, right? Okay? Especially for private company, it's not. So what you need to do is, when you transfer, how does transfer effectuate? By transferring share certificates, right? I have to get the possession of the share certificates, right? So what if I write something down on the share certificate? Okay? What if I write down on the share certificate that the shares transferability is restricted so that the other guy cannot say, I am unaware of such a restriction. I bought it in good faith, therefore you have to give me the ownership. Transferability is a fundamental feature of a stock, and I got it, I paid my money, I am the rightful owner. How do you prevent that? Something called the legend. So, all certificate evidencing the share shall be imprinted with a legend that reads substantially as follows, right? This security is subject to the restriction on transfer as set forth in article something of Articles of Association. So you want to say, since this JV is a kind of confidential document, however, you want to say in the Articles of Incorporation, put it in, even though it is held invalid, put it in. And also the Article 5 of the Joint Venture Agreement, dated when this was actually signed, a copy of which is on file at the principal business place of the company. Something of that. You print it on the back of the share certificate or something, okay? So that they cannot deny it, right? That adds a credibility of your argument that you cannot be a bona fide purchaser, right? That undermines that argument. So that's why you have to print it in bold or big enough letter so that it is easily noticeable. You understand? Okay? So that's why usually they do this kind of transfer restriction. Just put it on the certificate. All right?